Hello, I'm David R. Schneider, estate planning attorney, and welcome back to our series of videos on estate planning basics. This is a short video in summation of some of our earlier videos where we talked about the revocable living trust, the pour-over will, and the durable power of attorney. When these three tools are used effectively together, we create a complete estate plan when it comes to the asset management of all of the assets owned by you, the settlor of your trust. When we utilize these three plans together, I can tell you that I can make a 100% prediction. We have a program in place where we can answer 100% of the questions about 100% of your property 100% of the time. And in fact, I only ever have to ask up to a total of 3 questions to figure out any problem before us. The very first question I ever ask is, who owns the asset? Now, if there's a house, there's a deed. If there's a car, there's a pink slip. Bank accounts and brokerage accounts have statements. Life insurance has policies. Corporations have stock. LLCs have member share. And the paper does not lie. We look at the paper and we find out who owns the asset. So if I have a deed in my hand and the deed says property of Bob and Bobette Smith, trustees of the Smith Family Living Trust, then we know that the asset belongs to the trust. The asset's titled to the trust. All we have to do is read what the trust says and we're done. One question, we're finished. Somebody brings me another piece of property. Again, I ask the first question, who owns the asset? And I look at the piece of paper, perhaps as an example, a pink slip to a car, and the pink slip says simply Bob Smith. Well, who owns the car? Bob Smith. Second question, is Bob Smith dead or alive? Well, are we ever guessing when it comes to whether somebody is dead or alive? No, the paper doesn't lie. We either have a death certificate or we don't. If we have a death certificate, then Bob wrote a pour-over will. The pour-over will says exactly what to do. In 2 questions, we've answered the question. We've answered the question about the property. So somebody brings me another asset. Hey Dave, we don't know what to do with this particular asset. We simply go through the questions. Who owns the asset? If I look at this asset and the statement, let's say it's a IRA from Merrill Lynch. Who owns the asset? It says right on the statement, property of Bob Smith. Second question, well, is Bob dead or alive? Well, we saw Bob this morning. He was at the local shopping center parking lot. He was picking up string in the parking lot. So clearly Bob's alive. Third question, is Bob sane or has he become incapacitated? And once again, the paper does not lie. We either have a statement from an attending physician who's made a physical examination of Bob, stated on his or her letterhead whether or not Bob is competent to handle his own affairs, or perhaps we have a statement from a court of competent jurisdiction, like a conservatorship statement, or we don't. We have it or we don't. And if we do have it, Bob created a durable power of attorney for asset management before he became incapacitated, and we have our tool in place to manage his, in this case, IRA. Up to 3 questions is all it takes, and we can answer all the questions, 100% of the questions about 100% of the property, 100% of the time. If you would like more information about this topic or any of the topics in our series of videos, or to book a free no-obligation consultation with me, please give our office a call, David R. Schneider, 805-374-8777. Or please visit our website at drs-law.com.